Well, it's not every day that the nation's criminal defense bar receives a visit from the Attorney General. In fact, it isn't even every decade. As far as I can tell, this is only the second time in history that an incumbent Attorney General has addressed the nation's criminal defense bar assembled. So, Mr. Attorney General, we are truly honored to have you join us this morning, but not merely because of your title or your position, but because of the content of your work, which is far greater than that of Chief Prosecutor. To be sure, it is no secret there are many issues on the defense bar's to-do list that still must be addressed by the Department of Justice. And I know from our meetings with your staff and with you that you're aware of our concerns about things like discovery and Brady reform, the role of disclosure violations in contributing to wrongful conviction, our concerns about forfeiture and pretrial restraint of assets, and, of course, our enduring concern with the continuation of capital punishment. All of these issues must be tackled, and I'm confident in due course they will. But it is also a fact that issues of grave concern that have long been on the defense bar's to-do list, issues that have been neglected for far too long, now have the check marks of progress thanks to your stewardship. I want to mention to you all three issues in particular on which Eric Holder has broken new ground in advancing the cause of justice, issues that resonate deeply within the heart and soul of the criminal defense bar. In his public statements, in the department's programs, and in official policy, Eric Holder has eloquently and repeatedly focused attention on the importance of the right to counsel and the nation's failure to fulfill the promise of Gideon. He's declared that quote, the fundamental integrity of our criminal justice system and our faith in it depends upon effective representation. I stand with you, he said, and anyone who is committed to ensuring the Sixth Amendment right to counsel. These are not words that are heard all that often from attorneys general, but these are words that have been backed up by deeds. The Justice Department has expanded the nature and quality of its commitment to support training and technical assistance to those lawyers who represent the indigent, both public defenders and private assigned counsel who carry so much of the load of indigent defense in this country with so little support. NACDL is proud to partner with the Bureau of Justice Assistance in a range of programs that include training and technical assistance for capital defense lawyers, for those handling non-DNA wrongful conviction cases, and targeted trainings and assistance to indigent defense providers in under-resourced areas throughout the country. Now, NACDL is only one of many great organizations and bar groups that the Justice Department has enlisted in a concerted effort to fulfill the promise of Gideon. Thousands of lawyers and countless accused persons have benefited from these programs and will continue to do so in the years to come. The support for indigent defense reform has also been evident in policy. A year ago, in a case that challenged systemic deficiencies in certain counties in the state of Washington, the Justice Department filed an unprecedented statement of interest declaring that the United States has an interest in ensuring that all jurisdictions, federal, state, and local, are fulfilling their obligation under the Constitution to provide effective assistance of counsel to individuals facing criminal charges who can't afford attorney. A second issue on which Attorney General Holder has broken new ground concerns wrongful conviction and how to respond when it learns that flawed forensic science evidence has been introduced against an accused, specifically with respect to situations in which the microscopic hair analysis evidence has exceeded the limits of science. The Department has supported a review and defense notification process in which NACDL has been partnering with the FBI and the Innocence Project. After many years of neglect, this Justice Department has endorsed and supported a protocol that can become a model for how to deal with this problem in other contexts. Finally, and most importantly, this Attorney General has attacked a problem that has ripped at the guts of every defense lawyer in this country: the problem of cruel and draconian sentencing. The Attorney General has boldly declared too many Americans go to too many prisons for far too long and for no truly good law enforcement reason. My next line was to ask you if you could honestly say that you ever expected to hear words like that from an Attorney General, and you've already answered that, because I know I never did expect to hear that. And Eric Holder has, in fact, backed up those words with deeds as well. He's put forth a new, more flexible charging policy. He supported a reduction in mandatory minimums. He supported a guideline reduction for drug sentences. He's called for more diversion, alternatives to incarceration, and robust reentry programs. And he has courageously confronted a cold reality that we in the defense bar have witnessed for decades: racial and ethnic disparity in the criminal justice system. Last year, he told the ABA House of Delegates, we must confront the reality that people of color often face harsher punishments than their peers. And just this week, the Attorney General has again expressed concern about sentencing approaches that disadvantage minorities and the poor. And of course, last January, his department announced an unprecedented clemency initiative to provide relief for nonviolent inmates who likely would have received substantially lower sentences if they were sentenced today for the same offense. As I mentioned, NACDL is fully engaged with its partners in answering the call to provide pro bono representation to those who may qualify for relief. For the first time in decades, there is a growing sense in this country that the tide is turning against the national thirst for ever harsher, longer, crueler sentences. For many who had lost hope, the dream of freedom has been rekindled. When the clemency program was announced, Jerry Cox said that this could mark the end of the age of mass incarceration. Well, if in fact all of these steps mark the beginning of the age of the end of mass incarceration in America, and I know it's a big if, because ultimately sentencing reform hinges on congressional action and clemency depends upon presidential action. But if it happens, history will record that the man who was about to address us was pivotal in making that dream a reality: the Attorney General of the United States.
Thank you. Thank you. Well, thank you, Norm, for those extremely kind words. I think I want to take you back to Washington with me. There's some people down there who don't necessarily share your views of me. But let's not go there today. But I also want to thank you for your exemplary leadership as Executive Director of NACDL. It's a pleasure to share the stage with you this morning. And it's also a great privilege to stand with dedicated leaders like NACDL President Jerry Cox and so many distinguished jurists, passionate public servants, members of the defense bar, and engaged citizens. I want to thank this organization's entire leadership team, staff and membership for bringing us together this morning and for everything that this group has done in the 57 years since your founding to help expand the access to justice, to strengthen the rule of law, and to draw America's legal system ever closer to the values of equality, opportunity, and justice that have defined our profession and have shaped this nation for more than 2¼ centuries. Now, since 1958, the attorneys and staff of NACDL have exemplified, I think, the finest traditions of service and advocacy, striving to ensure justice and due process for those who stand accused of crime and misconduct. You've long stood at the forefront of our efforts to improve the administration of justice for all litigants, and you've worked tirelessly to educate practitioners, the public, and the judiciary about matters ranging from mass incarceration to the indigent defense crisis, consistently speaking up and speaking out for populations that are too often overlooked and too often underserved. Now, especially today, as we commemorate the 50th anniversary of the Criminal Justice Act of 1964, a landmark measure a great president, Lyndon Johnson, signed into law half a century ago this month to codify the Sixth Amendment right to counsel, it's appropriate that we pause to reflect on the invaluable contributions and the many sacrifices that this association's members and so many others have made to ensure equality under the law. But it's just as important that we mark this anniversary and honor the legacy of the Supreme Court's historic decision in Gideon versus Wainwright by recommitting ourselves to the work that remains unfinished undone and the significant challenges that are now still before us. As we speak, more than 5 decades after Gideon, 5 decades after Gideon, and 50 years after the Criminal Justice Act established a framework for compensating attorneys who serve indigent federal defendants, millions of Americans remain unable to access or to afford the legal assistance that they need. Far too many hardworking public defenders are overwhelmed by crushing caseloads or undermined by a shameful lack of resources, and it is shameful. And it's clear that despite the progress that we've seen over the years, a persistent and unacceptable justice gap remains all too real. Now, it poses a significant threat to the integrity of our criminal justice system. And meeting this threat will require bold action and renewed efforts from legal professionals of all stripes. Now, as my predecessor, Attorney General Robert F. Kennedy, reminded a gathering of legal professionals 50 years ago next week, it's incumbent upon us to ensure that the scales of our legal system, as he said, measure justice and not wealth. That's why this administration and this Justice Department in particular is committed to doing everything in our power to address the indigent defense crisis. Over the last 4 years, in spite of sequestration and other deep budget cuts, the Department of Justice has committed more than $24 million in grants, initiatives, and direct assistance to support indigent defense work around the country. The President's budget request for fiscal year 2015 will do even more in this regard. So Congress, let's get that done. And thanks to the hard-working men and women of the Department's Access to Justice initiative, which an office I launched over 4 years ago to improve access to counsel, to increase legal assistance, and to bolster justice delivery systems, we're working closely with state, local, and tribal and federal officials, as well as members of the bench and bar, to extend our outreach efforts and to broaden access to quality representation in both the criminal and also in the civil justice systems. Now, last summer, we took a significant step forward by, as you heard, filing a statement of interest in a class action lawsuit, Wilbur versus the City of Mount Vernon, asserting that the federal government has a strong interest in ensuring that all jurisdictions are fulfilling their obligations under Gideon. In December, in a pivotal decision, the United States District Court found that there had, in fact, been a systemic deprivation of the right to counsel and mandated the appointment of a public defender supervisor to monitor the quality of indigent defense representation. Now, these and similar efforts will help us meet our constitutional and moral obligations. And this is a moral obligation to administer a legal system that matches its demands for accountability with a commitment to due process. And they are only the beginning. Moving forward, we must continue to come together across aisles that divide council tables and political parties to ensure that America has a criminal justice system that's worthy of its highest ideals, to make certain that those who pay their debts to society have a fair opportunity to become productive, law-abiding citizens, and to empower justice professionals to meet 21st century crime challenges with 21st century solutions. Now, with this goal in mind, and again, as you heard, 1 year ago, I launched a new Smart on Crime initiative, which includes a series of targeted, data-driven reforms that are designed to achieve these goals. Since that time, my colleagues and I have implemented a range of what I think are meaningful changes by increasing our focus on proven diversion and reentry strategies, by making criminal justice expenditures both smarter and more productive, and by moving decisively away from outdated and overly stringent sentencing regimes. Now, I want to be very clear. We will never stop being vigilant in our pursuit of justice, in our determination to ensure that those who break the law are held rigorously to account. But years of intensive study and decades of professional experience have shown that we'll never be able to prosecute and incarcerate our way to becoming a safer nation. Now, As you know, the Smart on Crime initiative has led us to revise the Justice Department's charging policies with regard to mandatory minimum sentences for certain federal drug-related crimes, so that sentences will be determined based on the facts, the law, and the conduct at issue in each individual case. This means that the toughest penalties will now be reserved for the most serious criminals. Over the last few months, with the department's urging, the United States Sentencing Commission has taken additional steps to codify this approach, amending federal sentencing guidelines for low-level drug trafficking crimes to reduce the average sentence by nearly 18%. Going forward, these new guidelines will impact almost 70% of people who are convicted of these offenses. And last month, the Commission voted to allow judges to apply these revised guidelines retroactively in cases where reductions are warranted. Now, some have suggested that these really modest changes might somehow undermine the ability of law enforcement and prosecutors to induce cooperation from defendants in federal drug cases. But the reality is that nothing could be further from the truth. Like anyone who served as a prosecutor in the days before sentencing guidelines existed and mandatory minimums took full effect, I know from experience that defendant cooperation depends on the certainty of swift and fair punishment, and not on the disproportionate length of a mandatory minimum sentence. As veteran prosecutors and defense attorneys surely recall, and as our U.S. Attorney for the Western District of Wisconsin, John Vodrill, has often reminded his colleagues, sentencing guidelines essentially systematize the kinds of negotiations that routinely took place in cases where defendants cooperated with the government in exchange for reduced sentences. So with or without the threat of a mandatory minimum, it remains in the interest of these defendants to cooperate. It remains in the mutual interest of defense attorneys and prosecutors to engage in these discussions. And any suggestion that defendant cooperation is somehow dependent on mandatory minimums is plainly inconsistent with the facts and with history. Far from impeding the work of federal prosecutors, these sentencing reforms that I have mandated represent the ultimate expression of confidence in their judgment and also in their discretion. And that's why I've called on Congress to expand upon and to further institutionalize the changes that we have put in place, so we can better promote the public safety, deterrence, and rehabilitation while saving billions of dollars and reducing our over-reliance on incarceration. Beyond this work, my colleagues and I are also striving to restore justice, fairness, and proportionality to those currently involved with our justice system through an improved approach, as again you've heard, to the executive clemency process. In April, the department announced new criteria that we will consider when recommending clemency application for President Obama's review. This will allow us to consider requests from a larger field of eligible individuals who have clean prison records, who do not present threats to public safety, and who were sentenced under out-of-date laws that are no longer seen as appropriate. I'm pleased to report that we've already established an extensive and rigorous screening mechanism. We have facilitated efforts to engage assistance from pro bono attorneys, including many in this bar. We have detailed a number of lawyers within the Justice Department to temporary assignments in the pardon attorney's office. And we've taken important steps to establish a process by which we will consult with the U.S. Attorney's Office and the trial judges who handled each original case, so we can evaluate every clemency application in the appropriate context. Now, I'm particularly grateful for the assistance of dedicated criminal defense attorneys in and beyond this room, as well as nonprofit lawyers who have stepped forward to answer the call for experienced pro bono counsel. As our process unfolds, these associated groups, including NACDL and individuals who stand more than 1,000 attorneys strong and call themselves the Clemency Project 2014, will work with incarcerated people who appear to meet our criteria and request the assistance of a lawyer. Now, your efforts in this regard and your partnership in strengthening our criminal justice system across the board have been in keeping with the most critical obligation entrusted to every member of our profession, not merely to represent clients or to win cases, but to see that justice is done. Every day in courtrooms from coast to coast, criminal defense attorneys take on cases that are fraught with difficulty and often controversy, because you understand, I understand, that for our criminal justice system to function at all, every accused individual must have effective representation. And every defendant's right to due process must be guaranteed. Yet with the integral role that defense attorneys play in our justice system comes a tremendous responsibility to uphold the highest standards of conduct in every single case. Prosecutors and defense lawyers can agree that we all must act in good faith in discovery, including refraining from alleging discovery violations as a routine practice. Our overburdened court system is ill-served by such unfounded tactics. And the interests of justice demand that legal professionals look to their ultimate obligations, to strengthen the system as a whole, to address the disparities that divide and harm our society, to confront conditions and choices that breed crime and violence, and to harness innovative tools and new technologies in effective and responsible ways. Over the past decade, we've seen an explosion in the practice of using aggregate data to observe trends and to anticipate outcomes. In fields ranging from professional sports to marketing to medicine, from genomics to agriculture, from banking to criminal justice, this increased reliance on empirical data has the potential to transform entire industries and, in the process, countless lives, depending on how this data is harnessed and how it is put to use. With programs like CompStat, the New York City Police Department's management tool, which has been replicated and deployed in a number of police departments across the country, we've seen that data gathering can lead to better allocation of police resources. On the federal level, we know that the development of risk assessments has for years successfully aided in parole boards' decision-making about candidates for early release. Data can also help design paths for federal inmates to lower these risk assessments and earn their way towards a reduced sentence based on participation in programs that research shows can dramatically improve the odds of successful reentry. Now, such evidence-based strategies show promise in allowing us to more effectively reduce recidivism, and ultimately they hold the potential to, I think, revolutionize community corrections and make our system far more effective than it is today by better matching services with needs, by providing early warnings whenever supervised individuals stray from their reentry plans, and by incorporating faster responses from probation officers to get people back on track, and by yielding feedback and results in real time. So it's increasingly clear that in the context of directing law enforcement resources and improving reentry programs, intensive analysis and data-driven solutions can help us achieve significant successes while reducing costs. But particularly when it comes to front-end applications, such as sentencing decisions, where a handful of states are now attempting to employ this methodology, I think that we need to be sure that the use of aggregate data analysis won't have unintended consequences. Now, here in Pennsylvania and elsewhere, legislators have introduced the concept of risk assessments that seek to assign a probability to an individual's likelihood of committing future crimes, and based on those risk assessments, make sentencing determinations. Now, although these measures were crafted with the best of intentions, I am deeply concerned that they may inadvertently undermine our efforts to ensure individualized and equal justice. By basing sentencing decisions on static factors and immutable characteristics like a defendant's education level, socioeconomic background, or even neighborhood, they may exacerbate unwarranted and unjust disparities that are already far too common in our criminal justice system and in our society. Criminal sentences must be based on the facts, the law, the actual crimes committed, the circumstances surrounding each individual case, and the defendant's history of criminal conduct. They should not be based on unchangeable factors that a person cannot control, or on the possibility of a future crime that has not taken place. Equal justice Equal justice can only mean individualized justice, with charges, convictions, and sentences befitting the conduct of each defendant and the particular crime he or she commits. And that's why this week, the Justice Department is taking the important step of urging the Sentencing Commission to study the use of data-driven analysis in front-end sentencing and to issue policy recommendations based on this careful, independent analysis. At the state level, data-driven reforms are resulting in reduced prison populations, and importantly, those reductions are disproportionately impacting men of color. We should celebrate this milestone. This is potentially a turning point, and hope that front-end applications can also result in both public safety and racial justice. But careful study of this issue is extremely warranted. We are at a watershed in the debate over how to reform our sentencing laws. A generation ago, the truth in sentencing movement of the 1970s and 1980s sought to mete out equal sentences across the board, but sent the prison population soaring. By contrast, the idea of sentencing defendants based on risk factors may help to reduce the prison population, but in certain circumstances, it may run the risk of imposing drastically different punishments for the same crimes. Neither approach may by itself provide the answer. Instead, policymakers should consider taking the good parts of each model. The legacy of the truth in sentencing era is a lesson that the certainty of imposing some sanction for criminal behavior can indeed change behavior. And the big data movement has immense potential to make the corrections process more effective and efficient when it comes to reducing recidivism rates. A blending of these approaches may represent the best path forward. Of course, whatever the outcome of this debate, there's no doubt that there are complicated questions that implicate extraordinarily difficult issues. We seek, and we are bringing about, nothing less than a paradigm shift in our approach to criminal justice challenges. Ultimately, we're striving to turn the page on an era and an approach that relied on incarceration over rehabilitation, that emphasized punishment over outcomes, and that too often discounted the ability of our justice system to prepare criminal defendants to re-enter their communities as productive members of society. Now, through the Smart on Crime initiative, we have already achieved, I think, a tremendous amount. As we move forward together, my colleagues and I will continue to rely on leaders like you to advance, to hone, and to grow this work. This morning, as I look around this crowd of passionate professionals and dedicated public servants, I cannot help but feel confident in our ability to do just that, to develop smart solutions to the toughest problems that we face, to protect the rights of everyone in this country, no matter their salary or their skin color, and to further enshrine the ideals of American justice into the annals of American law. The very existence of organizations like NACDL reminds us that no matter how complex the challenges or how contentious the debate, there will always be men and women who do not shrink from the responsibility to bring this country closer to its highest principles and its deepest values. Even in the face of great trial and great challenge, despite criticism and public scrutiny, you have for nearly 6 decades remained faithful to your mission to ensure justice, foster integrity, and promote the fair administration of our criminal justice system. So I want to thank you once again for your inspiring commitment to these efforts. I applaud your dedication to principled and inclusive leadership of America's legal community. And I look forward to all that we'll achieve together in our ongoing efforts to deliver on the promise of equal justice under law. Thank you very much.